On January 3, 2025, at 9:47 a.m. Eastern Time, the United States District Court for the Southern District of New York unsealed nearly 1,000 pages of documents that had been sealed for years. This wasn't a leak. Senior District Judge Loretta Preska, appointed by President George H.W. Bush in 1992, ruled that public interest outweighed privacy concerns. The case, Giuffre v. Maxwell, a defamation lawsuit settled in 2017 that left behind depositions, witness statements, and flight logs naming powerful figures across politics and finance. Among those named multiple times, Donald J. Trump, 45th President and leading 2024 Republican candidate. By 2:34 p.m. that afternoon, Trump posted on Truth Social calling it another witch hunt and claiming he banned Jeffrey Epstein from Mar-a-Lago decades ago. Standard playbook: attack the process, deny, control the narrative. But by 6:51 p.m., according to archived screenshots, that post vanished, not edited, deleted. And that deletion raises a question cutting to the heart of criminal defense. Why delete your own denial? The unsealed documents stem from Virginia Giuffre's lawsuit against Ghislaine Maxwell, Epstein's associate now serving 20 years for sex trafficking. Media organizations, including the Miami Herald, fought for years to unseal these records. What do they contain about Trump specifically? A 2016 deposition from a witness who described seeing Trump at Mar-a-Lago in the early 2000s at a party where underage girls were present, stating Trump and Epstein appeared friendly. Phone records showing multiple calls between them during a 3-month period in 2004. Calendar overlaps placing both men at the same Manhattan and Palm Beach events between 2002 and 2005. Flight manifests don't show Trump on Epstein's private jet, but they document the social overlap. Does this prove criminal conduct? Absolutely not. Proximity isn't a crime. Many prominent figures, Bill Clinton, Prince Andrew, academics, businessmen, had Epstein connections before his 2008 conviction for soliciting prostitution from a minor. Trump's defenders note he distanced himself earlier than most, with reports of a falling out around 2004 or 2005, possibly over a Mar-a-Lago real estate deal. But here's what makes prosecutors notice: the deletion pattern. Trump has spent 8 years doubling down on every statement, attacking judges overseeing his cases, prosecutors investigating him, FBI agents executing search warrants. He called Judge Engoron biased in his New York fraud trial. He attacked special counsel Jack Smith investigating January 6th. In every legal confrontation, his instinct is to fight. So when someone with that documented pattern suddenly deletes a denial within hours, experienced prosecutors see a break in pattern. And breaks in pattern indicate pressure, indicate someone realized they made a mistake. What changed in those 4 hours? Possibility 1. His legal team found the Mar-a-Lago ban claim was contradicted by evidence in those very documents. A provably false statement becomes Exhibit A if prosecutors later charge obstruction. Possibility 2. Attorneys recognize the post could be interpreted as witness tampering if SDNY still has active investigations into Epstein's network. Possibility 3. The deletion minimized digital footprint, because anything Trump says establishes what he knew and when. Let me explain consciousness of guilt, a doctrine every first-year law student learns. It allows prosecutors to introduce evidence of behavior suggesting someone knew they were guilty. Fleeing police, destroying evidence, lying to investigators, changing stories when confronted with contradictory facts. The theory, innocent people don't act like they have something to hide. Defense attorneys argue it's prejudicial. People delete social media posts for innocent reasons all the time. Maybe Trump's lawyers said the post was too aggressive. Maybe he wanted the story to die. But timing matters. Trump deleted a denial about documents he clearly knew existed within hours of posting, breaking his lifelong pattern of never backing down. Former federal prosecutors notice Eli Honig, ex-SDNY assistant U.S. attorney, told CNN on January 4th that while the documents raise questions, they don't prove criminal conduct. But the deletion would make me want to ask follow-up questions as a prosecutor. Why delete a simple denial? Alan Dershowitz countered that deleting a post has zero legal significance. Reading consciousness of guilt into that is prosecutorial overreach. Preet Bharara, another former SDNY U.S. attorney, said, "If I were advising Trump, I'd have told him to say nothing. The post and delete suggests he's not listening to counsel." Trump's legal landscape matters here because this doesn't exist in vacuum. As of January 2025, he faces 4 criminal prosecutions, federal charges in D.C. for January 6th, conspiracy, federal charges in Florida for retaining classified documents and obstruction, Georgia RICO charges for election overturn attempts, and New York State fraud liability exceeding $400 million. None directly involve Epstein, but they establish a pattern prosecutors can cite: allegedly obstructing investigations, allegedly pressuring witnesses, allegedly hiding evidence. The Epstein documents fit that mosaic. What statutes would govern potential investigation? If there were evidence of direct involvement in sex trafficking of minors, that's 18 U.S.C. 1591, but statute of limitations is typically 10 years from the offense. Events described occurred 2002 to 2005, potentially outside limitations unless there's evidence of recent conduct. Prosecutors could examine conspiracy charges under 18 U.S.C. 371. You don't need proof the defendant personally committed the underlying crime, only that they agreed to participate in a criminal enterprise. Most relevant, obstruction of justice under 18 U.S.C. 1512, criminalizing witness tampering or destroying documents. If prosecutors showed Trump's post and delete intended to influence potential witnesses or obstruct potential investigations, that becomes a separate crime regardless of underlying conduct. This is what happened to Martha Stewart in 2004, not convicted of insider trading, but of obstruction and lying to federal investigators. The cover-up became the crime. Politically, this drops into a volatile environment. Trump holds commanding Republican primary leads. Most polls show him above 50% among likely GOP voters. But Quinnipiac polling from January 5th to 9th, 2025 shows impact among crucial swing voters. Republican primary voters' favorability stayed at 71%. His base is solid, but among independents, favorability dropped 6 points from 41 to 35% in the week after document release. The poll asked, "Does Trump's past association with Jeffrey Epstein make you less likely to support him?" 47% of independents said yes. Among suburban women, a demographic Trump lost in 2020 that jumped to 59%. Financial impact has been subtle but real. Trump raised $19 million in Q4 2024, strong numbers showing donor enthusiasm. But Washington Post reporting found at least 3 major donors who'd committed 7-figure contributions to Trump-aligned super PACs put those commitments on hold after January 3rd. One told the Post anonymously, "I believe Trump when he says he wasn't involved in Epstein's crimes, but the optics are terrible. I need to see how this plays out." This mirrors October 2016 when the Access Hollywood tape dropped. Some major donors fled, but most returned within 2 weeks, calculating Trump still represented their best chance for policy outcomes they desired. The question, will Epstein associations, touching far more serious allegations than crude comments, follow the same rebound pattern? Republican leadership has been notably quiet. Mitch McConnell declined comment. Speaker Mike Johnson said he hadn't read the documents. Former VP Mike Pence issued a carefully worded statement. Every American deserves the full truth about Jeffrey Epstein's criminal network, and anyone who participated should be held accountable regardless of position or party. That doesn't defend Trump, but doesn't accuse him either, the careful line many Republicans walk. They can't alienate Trump's base, which dominates primaries, but recognize independents are increasingly uncomfortable. Democratic strategy has been restrained. Biden's campaign hasn't run ads about the documents. Party officials largely avoid commenting beyond, "Voters should have all facts." This likely reflects multiple calculations. Bill Clinton's name also appears in Epstein-related materials, creating blowback potential. There's political wisdom that Trump's legal problems are already known, and piling on might create sympathy backlash. Democrats may calculate the documents speak for themselves and responsible media coverage does the work. History offers crucial context. Bill Clinton faced Paula Jones's 1994 sexual harassment lawsuit related to alleged incidents when he was Arkansas governor. He claimed presidential immunity. The case led to his deposition, where he lied about Monica Lewinsky. That lie became the basis for 1998 impeachment for perjury and obstruction. The Senate acquitted him, and his approval ratings actually increased, suggesting the public separated personal behavior from job performance. But crucial difference, Clinton faced civil litigation and impeachment, political processes. Trump potentially faces criminal investigation with different rules and consequences including prison time. Bill Cosby provides another parallel. For decades, multiple women accused him of sexual assault, but he maintained innocence and faced no charges. Then, in 2015, a deposition from a 2005 civil lawsuit was unsealed, showing Cosby admitted obtaining quaaludes, intending to give them to young women he wanted sex with. That admission, combined with Pennsylvania extending statute of limitations, led to criminal charges and conviction, later overturned on procedural grounds. The lesson: unsealed civil case documents can have dramatic criminal consequences years later. Prince Andrew's connection to this exact plaintiff matters too. Virginia Giuffre sued him in 2021, alleging he sexually abused her at 17 at Epstein Properties. Andrew's disastrous BBC interview claiming he was at Pizza Express in Woking and couldn't sweat due to Falklands War medical condition contradicted evidence. Queen Elizabeth stripped him of military titles and patronages. He settled for reportedly £12 million without admitting liability, purchasing his way out while suffering severe reputational consequences. For Trump, settlement isn't an option. These aren't lawsuits against him, but documents from cases between other parties that mention him. Finally, Watergate's 18.5-minute tape gap. When Nixon was forced to turn over Oval Office recordings, one crucial tape had a mysterious gap right when he would have discussed the cover-up. His secretary claimed accidental erasure, but experts concluded it required multiple manual operations, suggesting deliberate action. The gap itself became consciousness of guilt evidence. The Supreme Court ruled it demonstrated Nixon knew he had something to hide. While deleting a Truth Social post isn't equivalent to erasing White House tapes, the legal principle is similar. Media coverage reveals America's fractured information ecosystem. The New York Times ran page 1 with "Sealed Epstein files released, naming Trump and others," meticulously sourced with extensive court document quotes. They noted Trump's deleted post in paragraph 12, framing it as unusual for the former president, who typically doubles down. The Washington Post emphasized the unsealing process with legal expert analysis. The Wall Street Journal ran "Court releases Epstein documents, Trump among those named," emphasizing many prominent people were mentioned, and inclusion didn't imply criminality. On cable, MSNBC featured former prosecutors discussing consciousness of guilt doctrine and speculation about SDNY investigation possibilities. CNN brought prosecution and defense analysts for balanced discussion of what documents proved versus suggested. Fox News spent little prime time on the story. When covered, hosts emphasized Trump's denials and his Mar-a-Lago ban claim, with Tucker Carlson suggesting the release was politically timed to damage Trump's campaign, providing no evidence and ignoring that unsealing came through years of media organization litigation, not government prosecutors. On social media, hashtag Trump Epstein Files trended number 1 in the U.S. for 18 hours. Stanford Internet Observatory analysis found 62% of tweets critical of Trump, 31% defensive or attacking document credibility, 7% neutral. They also found coordinated inauthentic behavior, bot networks amplifying both pro-Trump and anti-Trump messages, suggesting actors inflaming divisions regardless of side. On Truth Social, reaction was overwhelmingly defensive, with users posting memes comparing this to previous witch hunts and sharing Clinton-Epstein photos. The deletion was barely discussed there. 3 scenarios for the next 6 to 12 months. Scenario A, 40% probability, nothing happens criminally. SDNY reviews documents ensuring all Epstein co-conspirators were identified, but concludes insufficient evidence for charges against Trump or anyone newly named. Documents remain a political issue used in Democratic ads, questioning Trump's character while Republicans dismiss them as old news. The story becomes one more data point but doesn't fundamentally change the race. Trump wins the nomination and the general becomes a referendum on Biden's record versus Trump's presidency, with Epstein as background noise. Scenario B, 35% probability, congressional Democrats launch investigations with subpoena power, calling witnesses named in documents and demanding testimony from Trump associates. This becomes political theater like Benghazi hearings or impeachment inquiries. Lots of media coverage and partisan combat, but no criminal charges because Congress lacks prosecutorial power. It probably helps Trump with his base, who see persecution while alienating independents exhausted by constant investigations. Helps him secure nomination by rallying Republicans, but hurts in general election by keeping problematic associations in headlines. Scenario C, 25% probability, SDNY, opens formal investigation, not necessarily into whether Trump committed Epstein's crimes, but narrower questions. Did anyone lie to federal investigators during original Epstein investigation, obstruct justice, or engage in witness tampering? This proceeds slowly with grand jury testimony through spring and summer 2025. Probably no indictments before the election due to DOJ policy against actions close to elections that could influence outcomes. But the investigation's existence becomes massive politically. Trump attacks it as election interference, Democrats say it proves accountability needs, and Americans vote for or against a candidate under active federal investigation. If Trump wins while under investigation, he potentially appoints a new attorney general to shut it down, creating constitutional crisis about self-dealing. What we don't know matters enormously. Documents released January 3rd represent only a portion of total Epstein files. Some remain sealed due to ongoing investigations or because they involve minor victims whose privacy courts protect. More documents may be released in coming months. Redacted names in current documents might be unredacted if courts determine redaction reasons no longer apply. This means the story isn't over. Each new release could bring new revelations. For Trump and others named, this creates perpetual uncertainty. They don't know what else might surface, what other witnesses said under oath. That uncertainty creates pressure and opportunity for prosecutors offering deals for cooperation. We must distinguish what we know as established fact from reasonable inference from speculation. Established fact: court documents show Trump had social relationship with Epstein in early 2000s, was present at events where Epstein brought young women, and had phone contact during that period. Established fact: Trump posted response to document release, then deleted it within hours. Reasonable inference: Trump's legal team likely advised deletion because it created legal risk or was provably inaccurate. Reasonable inference: prosecutors reviewing documents would want to interview witnesses who placed Trump at Epstein events to determine what he observed or knew. Speculation: whether Trump had knowledge of or involvement in Epstein's crimes. Speculation: whether SDNY will open criminal investigation. Speculation: ultimate political impact on 2024 election. Maintaining these distinctions matters enormously because one of modern media's most corrosive trends is blurring fact, inference, and speculation into undifferentiated information. Watch for these developments. Any indication SDNY convened a grand jury or issued subpoenas. First concrete sign of criminal investigation. Trump's legal filings in existing cases. If he references Epstein documents or argues unfair targeting, that reveals legal strategy and concern level. Polling among independents and suburban women: if Trump's numbers continue sliding with those groups, it pressures Republicans to reconsider whether he's the strongest general election candidate. Additional document releases. Miami Herald and others continue litigating for more Epstein files access. What Trump does he continue attacking, go silent, or try changing the subject? His behavior tells us whether his team believes this is a serious threat or manageable problem. This story is really about three fundamental questions facing American democracy. Does rule of law apply equally to most and least powerful, or do wealth and position create effective immunity? Can our systems distinguish legitimate accountability from weaponized investigations, or have we entered an era where every allegation is assumed politically motivated? Do voters care about character anymore, or has politics become so tribal that career-ending allegations a generation ago now become more partisan ammunition? We don't have answers yet. The Epstein document release won't resolve them, but it forces us to confront them in uncomfortable and necessary ways. This isn't over. More documents may surface. Investigations may open. Political consequences will play out heading toward one of the most consequential elections in American history. Stay informed, read actual court documents if accessible, listen to legal experts from multiple perspectives, distinguish fact from speculation, and demand our systems deliver accountability based on evidence, not political expedience or partisan loyalty.